Okay, so we're going live to contradict the lies contemplated by really cool news. I went to the Lane Myers hearing Tuesday, the 11th, for the revocation of probation. And I got to meet the wonderful, really cool news Jodi, the cream of the crop journalist here. She made several allegations. One, she was the one that started talking to me and asked my name, all because I was talking to somebody else and said she was the enemy. And then she wanted to know more about me because I seemingly knew who she was. And then when they went to break, maybe because there was some recording, maybe not, I had nothing to do with me. And I asked her if she wanted to talk, and she said yes. And then I continued to talk to her, and then she gave the attitude that she gives in her interview with really cool news, including the allegation that common courtesy, when a hearing gets over, you hold the elevator in case anyone else might want to use it, is somehow a creeper move. This is the allegations being propounded by really cool news on their stupid YouTube page. And here we go. Let's bring up the AI so we don't even have to show all references to Jason Jensen, a private person mostly. So here we go.
To the judge said that someone was streaming. That person who was streaming turned out to be Jason Jensen, who, well, this is allegedly.
No, it's not. It's not allegedly. It's a bunch of lies. I absolutely did not stream or record anything. And why would I? This is so much better. I get to do what Jodi does and claim what happened based on my integrity and blah, 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 right? Because there's no audio file. So what we do is we write down notes and we narrate whatever we want to represent what happened in court. Like we're going to drag my name through the mud just because I dared to go watch the hearing. And that's what's wrong with these people. It's all division politics. You're either on their side or you're the enemy. And that's what they're going to do, is try to get you in trouble by promoting it was you unlawfully recording, facing contempt for allegedly recording. But that's not true. Didn't record, and I don't need to record. I wanted to do the same thing that really cool news does and just make up crap.
Right now, but he was apparently streaming chat of the first couple hours of the proceedings. We're not sure where he was doing that, but he was instructed to stop recording. So he apparently put his phone down.
I never got that instruction. There was no instruction made to me. After we came back for lunch, the bailiff came over and told me I had to turn my phone off. That was it. There was no allegation that I ever heard in court or otherwise that alleged that I was the one recording. And she made all this up because she doesn't like my opinion.
Down. They had the break. They came back from break. What we got at lunchtime was, or after lunch time, we had Judy for lunch here. Judy basically said they got back on track, and that the afternoon break came, and she said they'd finished quickly with probation and no recross of the probation officer. Then Lane's wife, Lane's girlfriend, said came out and said under oath that Lane had extended some sort of debt in her name, and that was the last straw that broke the camel's back. She said they were done. So that confirms Liberty Trolls reporting last night that basically, yeah, they're donezo right now. Now, again, if you do super chats, if you want to keep us going, super chats or anything, please. I can't highlight you right now. Touche's back with us. Hey, Touche. Welcome back. We're just recapping Jason Jensen. It was Mrs. Tom. So the victim's husband was the third and final witness for the prosecution. He gave a brief history of what was going on between his wife and the spiraling that Lane had done all summer. Resnick's objections had all fallen through or been overruled, and Lane was getting louder and more agitated, and that's where we left off. Her new update before she started the drive home was just simply, I'm headed home now, Lane is not, and that there's going to be another hearing on Thursday. So, yeah, this is going to be interesting. We will do another marathon or another session on Thursday, provided that Judy is okay to go back to court. And unfortunately for Judy, they no longer offer in stock the notebooks. I checked there. Yeah, I can't get a notebook, so I'm gonna double check that.
I don't care what these people have to say,
throw that on,
especially after they torpedoed
the big
me.
sticker.
And that is when the gentleman that's sitting in my row gets a buzz on his phone, hops up, talks.
That's not what happened. A woman got a buzz on her phone and her watch, and it made an audio noise, and she tried to silence it, and the bailiff came over and made her leave the courtroom to figure out the situation. So there's no way Judy made this misunderstanding. She's false reporting. She's full of crap. And that's the truth of it. And she torpedoed me because, as she says,
to the sheriff's deputy that is the one sitting right behind Mr. Myers to make sure he doesn't pop off, who then says, Judge, I need to speak with you. That's when we find out that allegedly Jason Jensen is streaming.
I don't know where she got that information with my name. I was in the same courtroom and I never heard my name, and the judge threatened with contempt, so he would have had some sort of relevance to me. And process there would have been that he asked me questions. And in no unequivocal terms, I did not record anything yesterday. I didn't record from 9 a.m. to 4:30 p.m. Didn't record anything.
The audio from the court.
Do we know his YouTube channel?
I don't.
Yeah.
Okay.
Yes, we had that earlier. But he was not. There was no sign of a YouTube stream.
That's because I did no streaming. Right? Now he's looking at evidence. These people are supposed to be news gathering. Really cool news, man. They're supposed to be representing themselves as journalists, but they have no integrity. And it's all this divisional politics. So you're either on their side or you're the enemy, and they're going to torpedo you and drag your name through the mud. And what did I do here? I had the audacity to go to a hearing and socialize with people.
Now, that
Okay.
does not mean he was not privately doing it, maybe
Yeah.
through Teams.
That's not how anything works. It's not that I have to prove that I didn't record. The burden is on them to prove that I was recording. And see, they're trying to get me in trouble here. They're saying they're advertising that I was the one who did this recording so that I get in trouble, right?
Call
Yeah.
or a Slack channel.
Okay.
All it means is they got a notification that the audio was being streamed somewhere. So
And after that,
Somewhere, and somehow they magically decided that somebody who's getting involved with the politics is the person that was doing it. Magically. You know, there's no conflict of interest there or nothing like that, right? Because, you know, you're just naming a person and trying to claim, like, oh, you're completely innocent about it. The word allegedly protects you, even though this is your logic behind making the statements. You even looked at my YouTube channels, and there's no evidence corroborating what you think, but you're still going to propound it anyways because you're reckless.
sheriff's deputy made sure everyone's phones were off. You could not use your phone inside the courtroom at all, had to go out into the hallway. And that included the reporter from Arizona Republic. Because
As much stupid shit as that was, the reporter from Arizona Republic apparently, according to Jodi, had to turn off her cell phone but utilized a laptop the entire time to verbatim type most of what was going on in the hearing. So she's got this smile and she thinks it's all funny. And, oh, look at this. They made everybody turn their phone off. Ha ha ha. Except for a laptop was available for use for the, the real official reporter type.
as normally reporters get that courtesy of being able to tape, to audio record the hearing so they can check themselves afterwards. I think it's basically known that you don't stream it or, publish it anywhere. It's a check to make sure that you got the facts correct. She wasn't even allowed to audio record it today. So we come back in after that break. And we just keep going through that poor probation officer who's the interesting part of Cross was that Mr. Resnick was like, well, what about his live streams made you want to arrest him? Because normally with probation, and instead of going to revoke right away, you try to curb that behavior that was getting you into trouble. Some education, some extra picking up trash along the sides of the road, something to say, hey, don't do that again. Except that as far as the victim and her husband were concerned, Mr. Myers' behavior started.
The guy didn't care. He was told by his boss to violate Lane Myers, so he did. And he didn't remember any of the videos. In fact, he basically said he didn't have time to watch hundreds of hours of videos for this. He had 200 people he was supervising. And look, I keep posting, that I made no recordings, and they keep removing them. Well, it looks like maybe it's still on there now. But I made another post and that was removed. Let's see, let's move on here.
And I can see, I mean, Jason Jensen tried to get into an argument with me about, was he convicted versus did he plead?
See, this is the problem with this kind of reporting and why the court should provide audio. I mean, she's completely off base here. We were in the hearing, and I was joking that she was the enemy, and that got her attention. And so she asked me my name, and we talked a little bit in the hearing, real quiet like, and then the judge called a recess. I think it was a 15-minute mid-morning. It was right around 10 something. And then when we come out, I had two options: continue the conversation with her or go outside and smoke a cigarette. I wish to God I would have went outside and smoked a cigarette. This woman is the most inconsiderate person ever. I even asked her if she wanted to speak more, and she said yes, and then she just didn't like what I was saying, so then she acted like I was bugging her on the phone. And I even said that after she said that. So there was no misunderstanding here. It's selective reporting and dramatization. We're going to make this narrative anything about the elevator. And so then I started talking to her about the principles of the First Amendment and how normally when you have a story, people do ask the spouse. For example, Bill Gates had a problem with the Epstein stuff, and who did they ask? Melinda Gates. Why? Because that's over 100 years of news gathering and story building. That's just what you do. That's what Lane did. And then she started talking about how the First Amendment doesn't have absolutes, or really what she said is the law doesn't have absolutes. Well, the law does in principles. Like, for example, the rule of law is an absolute. You either have the rule of men or you have the rule of law. And where the rule or the letter of the law doesn't apply to everyone equally, that's not the rule of law. That's what equal protection is. So basically, she couldn't handle the argument and decided to attack me, and is now using Really Cool News as the vehicle to do that. Which, if she supports what happened to Lane Myers, I mean, she is basically doing the same thing to me on Really Cool News. Harassing me for the audacity of going to a public court hearing.
Dude, you're not worth the breath.
See? There we go. So why did she engage with me? I definitely didn't talk to her first. I was talking about her to somebody else. There's a big difference. That's not an invitation necessarily. And then I was nice about it.
Sorry, you are not worth my breath. Okay? So,
What does she think a plea is? When you plead guilty, what does she think?
Let's see here. I think it's Rule 17. Here we go. So, advising, determining a voluntary plea agreement, withdrawal of the plea, blah, blah, blah. What rule requires the judge to find basis of the plea to actually find guilt? And after this procedure, can you not call that a conviction? (17.3b) explicitly requires the judge to determine a factual basis for all guilty and no contest pleas before accepting. Blah, blah, blah. Can you call it a conviction after this procedure? Yes, it is legally considered a conviction. There we go. And then what really pissed off Jodi was after all of this nonsense, the prosecutor, Mr. Matthew, why am I forgetting his name? The victim's husband, maybe I shouldn't say it. He did file a petition with the Supreme Court of Arizona, Matthew Walker. And I even have some artwork there. Let's see here. There we go. Matthew Walker. Anyways, so he's testifying and he says that Lane Myers was convicted. And then I whispered to her, "See, conviction." And then she acted like a complete idiot because you can't possibly be wrong. Like, they're going to argue this stupid point now. Here, listen to them argue this stupid point.
That is.
He was like, but the judge, in order to sentence you, the judge has to.
Here we go. This is what I said right here. The basis of accepting the plea. Dude. 17.3b. So I even told her the correct rule, and this is the quality of really cool news reporting by Jodi.
Find you. What was he saying? He has
Rule 17
to find you guilty. I'm like,
has to find a factual basis to find you guilty, and then does.
I think we're
He
splitting hairs
did,
right now.
because you
Yeah.
admitted it.
Yeah.
You admitted it.
Yeah, that's a really good way of finding factual basis, but it's not conclusatory. For example, if you do admit to a crime you did not do, and it's obvious, and the judge has enough information in front of him to know that, then he is required by the law to reject your guilty plea and not find you guilty.
When you admit it, you're admitting to all of the facts presented.
Yeah, and then they use that as a basis to find you guilty, which is a conviction.
To the charge.
And they
That's what
ask you
when you
if
say
you've been
you're
coerced.
guilty.
They ask you if you've been coerced.
That's what guilty means. You were convicted in the court of law, so you're guilty. I mean, they don't even argue from like reason or logic or anything. It's all division. You know, what color hat are you wearing? You're not wearing the color I like, so everything you say is wrong and stupid and blah 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 blah.
Or
Yeah.
or
Were you promised anything?
yeah, exactly. And you say
Yeah,
no.
they had a whole list that they went down.
Yeah, it's Rule 17 right here. Right? Here it is. General provisions advising the defendant, determining voluntariness, written plea withdrawal, and of course it left out what it later says was Rule 3B. So,
before he accepted.
By the way,
And they do that with
Powerball-
every plea.
Powerball is at 1 billion now.
Oh, would
is
you
no
mind?
winner.
Oh
Would you
my
mind
God.
winning that for me, Gian?
I will.
appreciate
I'm on it.
Yeah,
In
yeah.
2 days.
Just
oh, and
Just
then
don't take
here's
your-
the final
Oh well.
coup de grace. Like, you can tell how spiteful she is towards my interests just because, I said she was the enemy. Well, I called that, right? She's on really cool news. It's obvious by her reporting that she isn't a reporter. She's a propagandist. She has a clear intention and a clear narrative to present, and it doesn't even try to be objective what she's doing for reporting.
Jason tried to get into the elevator with me, and I decided, nope, gonna go pee. Bye.
You know,
Oh my God, that was the best decision she ever made, because I was extending what's normally known as common courtesy. The hearing had just got over. I had just left. I had hit the button. The elevator had came, and I held the elevator door to see if anybody else wanted to use it. I think one other person got on, and we went down. That's called common courtesy, but she's going to try to make that out like it's some sort of creeper move. Like I cared to talk to her after she was obviously the way she is.
you know,
Yeah.
everybody wants to be close to you, Judy.
Yeah, no.
Hell no. Hell no. It was called common courtesy. Right? When you're in public, you're supposed to maintain some sort of respectable demeanor towards others. She obviously feels like she has some sort of exception to it and dramatization and, feeling self-important and whatever. So let's go over why I was there. By the way, this website is slow. They're replacing the software, which I can't wait for. This would be my petition. I made a contending petition than the one that was made by both Matt Walker. So he filed this one, and it was replaced with the task force petition. And that is exactly what caused Lane Myers to stop following the program. Hold on. Technical difficulties. So we have R26-0003. Let me see if I get that right from memory. All these numbers and acronyms. Oh, and this website is painfully slow. So this is the superseding petition by the task force of Arizona. It's commissioned, I guess would be the word, by the Supreme Court of Arizona. So what we're going to do is we're going to look for the AA something, APAAD or something weird like that. APAAC. And this is what they filed, which later caused Lane Myers to literally start talking about that. And because here we have the cause, right? So in court, they talk about how they want Lane Myers to succeed. And then you have the spouse of the victim going and filing a petition with the Supreme Court. And that one is also references Lane Myers. Do a little search for this. Oh God. So here is the original. And you can see it was posted by Matthew Walker, which would be related to the victim. And here's his petition. Blah, 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 blah. See example, Lane Myers wins 2 cases in a day. And is it still up? Oh, it isn't available anymore. But that was what set Lane Myers off. And so for him to go testify about how he has no idea why all of a sudden, let's see what the date is on this. This is January 2025. And this is April 2026. That is the same person, I believe, that he was contacting on the phone, demanding public records and screaming at, and etc., etc. Let's see if a judge had a little bit more ethics. Yeah, this seems like a very ethical approach, basically. Just wants it clarified in the rules that since there's now virtual proceedings, that the rule should incorporate that element, which is perfectly fine. That is a very respectable position to have in this petition. So then we have my petition. And we have the executive summary and table of contents. And we have the various chapters and page numbers, which is why I was at the hearing. You know, everybody's acting like I am on Lane Myers' side or something. This is also my video, right? So, kind of scourge person and has been found guilty. But the fact that I think that the courts should be open, okay, so makes me the enemy. Because, you know, you have these idiots on YouTube they are championing the idea that courts should act in the dark of night over the most trivial things. Like, for example, you can't protect this woman's identity. Who is Lane Myers' victim? Oh, gee. What does this say? Okay, well, the cat's out of the bag. There's no putting that thing back in the genie bottle. So, I mean, why even try? So now you have my petition, and it starts off, and it says that it wants to replace the current discretionary request-based structure with a presumption of public recording, broadcast, and permanent archival of court proceedings, subject to narrow on-the-record exceptions. This petition is filed as a companion and counter-proposal to their "Let's use Lane Myers as a good reason to restrict the courts even more." Right? Because that doesn't seem like it's in the realm of ethics, which all lawyers are supposed to be doing, especially when they make a petition to change the rules and structure of those courts. Let's see if this works. I'm going to try sharing something from my phone. Boop. Open with Ocular. So my petition was granted on an expedited basis, and it will be considered with the competing petitions. And that was signed by Ann A. Scott Timmer, the Chief Justice, Supreme Court of Arizona. So this would flip that on the head, and this whole thing with really cool news is a perfect example why nobody shows up and observes the courts. I got attacked for simply appearing and observing. Got accused of breaking the rules, committing contempt, criminal contempt probably, and some other nonsense. This petition is organized around a single governing principle. Judicial authority rests on the appearance of just authority, not its bare assertion. Where that appearance is placed permanently beyond the public's ability to test it, the underlying authority becomes indistinguishable from the public's vantage point, from judgment backed by nothing but words. Examples offered throughout this petition, including matters in which the petitioner has personally involved, are offered for this purpose alone. They are not offered to relitigate the merits of any case, to assert the guilt or innocence of any party, or to ask the court to make findings about disputed facts. They are offered because, whatever their ultimate resolution, the conditions under which they proceeded were not visible to the public in any meaningful sense while they occurred, and that invisibility, standing alone, is the harm this petition asks the court to address. The appearance of justice is the foundation of judicial authority. The proposition that courts require appearance of just authority and not merely its assertion is not a rhetorical device. It is settled law. In Offutt v. United States 348 U.S. 11, 14, 1954, the United States Supreme Court held that justice must satisfy the appearance of justice, a standard the court has applied ever since as independent constitutional concern. Distinct from whether any particular proceeding was in fact conducted fairly, the same principle is codified in the operative disciplinary standard of governing judges themselves. The Arizona Code of Judicial Conduct, like its counterparts nationwide, do not confine its concern to actual impropriety, but expressly reaches the appearance of impropriety as an independently sanctionable condition. A judge may be disciplined for the conduct that merely appears compromised, whether or not any compromise in fact occurred. If the law holds individual judges to that standard, the institution as a whole can claim no lesser one for itself. This is not a semantic point. It is only coherent account of why judicial authority commands obedience at all. I'm not going to read this whole thing, but the highlights are, this is the Federalist paper number 78, talks about how Alexander Hamilton observed that the court has no force nor will, merely judgment. And that branch of government is based on those words. That's where it gets its authority. And when you have black box decisions and you're trying to conceal the narrative, like for example, I'm sure Jodi doesn't attach to any of it, but basically the defense must have made, I don't know, somewhere around 20 objections. And what you can't see in the transcript is that judge ruled on even complex matters like attorney-client work product in rapid succession. I mean, whenever the prosecutor made an objection, there was this well-thought-out, developed record where there was back and forth between the parties. That's not what happened in this, in the case of when the defense made an objection. So you have the bullshit artist, and they have the martial law court. And then you have the bullshit artist trying to convey what happened with a clear agenda, which all these people are just promoting this nonsense. You're a rock star, yeah.
Everybody, you're so loving. Wonderful.
No. Get away.
Yeah. Ew, no.
Yeah, so, you know, what an attitude to have while you're claiming to gather news.
After the day I had, just get away.
Yep,
Everybody
get
just
away.
get away.
I get it.
I want the
Yeah.
dog, and the dog
Get
will
some
make
rest,
Simba.
yep.
Yeah, Simba's
Now-
waiting for me.
Enjoy
Let's
the
get
pups.
to the programming notes before we start losing people. We've got a record for us we had over 120 at one point
Yep.
watching.
Ooh, nice.
And that's on a non-biggin night. So,
Well, anyways,